Well, get him to come to the door. That'd be even better. And then ask the question.
We want to request if we could have our press conference inside.
Okay. We need to go outside for just a second.
Okay.
If we can request people to stay back away from the doors in case there's an emergency or anything like that.
Okay.
We have
I
a
can do
clear shot out
that,
the door.
but before I do all that, is it not possible to have our press conference inside the building?
No, this room here right now tonight is open for the defendants. We're going to bring all the defendants in at 7 o'clock into the conference room.
Okay, and so then what about members of public and the press who want to go into the courtroom?
They're going to be allowed to come in after we get the 10 defendants in.
Okay, and then they will be allowed to wait here inside?
The people that are...
Members of the public and the press. Once
they're gonna be
the
able to-
courtroom is full. We've got more than 49 people out there.
Okay.
So,
Yeah, only the defendants are going to be allowed in the conference room this evening.
so where will all the press and the
If the
other
press wants to
people?
leave their cameras and things like that and go into the courtroom, they can do that.
Okay.
Okay. They can't bring
But
them
after
inside.
after the courtroom is already at capacity
Mhm.
and people are coming and going, all the people who are waiting to get a seat in the courtroom.
If we have more defendants waiting in the conference room and somebody leaves, then the next defendant's going to be brought in.
Right. But what
Okay.
about the members of the public and the press?
When somebody leaves from the public, they can come in.
They can-
Another person.
But can we wait inside
No.
in the heated building?
No.
So everyone who wants to go into the court has to wait outside
When we-
until a seat opens up.
Right.
Okay.
Once we're at maximum capacity.
Right.
in the-
Good light. Okay. Who wants to open this?
Okay. Welcome everyone. I'm Sandra Steingraber with We Are Seneca Lake. And we won't do our usual cheer because court is actually in session and we are respectful of the rule of law, and so we'll allow what goes on in there to go on. Thank you for turning out. Our toes and our fingers are cold tonight, but our hearts are warm, and we want it to be known that according to the weather report I heard on the way over here, and so our theme for tonight is injustice at the court level, both what's happening inside to our defendants and Seneca Lake defenders, and also what's happening to us outside here. According to all the definitions that I have read, a courthouse contains a courtroom, and it can also contain a town hall. And so when I talked to the Board of Reading, who made this decision tonight to close the courthouse to the public, I was told this is not a courthouse, this is a town hall. And it's a place where public business is done, but that doesn't mean it's a public business, a public building. And that's what one board member told me. Marvin Switzer, who is the supervisor in the town of Reading, let me know that a decision had been made to close this building to us. It seems to be a decision specifically directed at us. He could not name any other groups of people who had been denied access to the building while court is in session. And when I asked why, we finally got my chance to open for her. So here is our star speaker of the night, Martha Robertson. We're so glad that you are here to bear witness to what we're doing.
Sandra, I think that segue from health and safety of standing outside to health and safety of gas-free, of the Crestwood project and what's happening and will happen to Seneca Lake was maybe the best segue I've ever heard. But it is really true, and this is an issue not just for the people of Schuyler County or the people who border Seneca Lake directly, because frankly in upstate New York and the Finger Lakes region, we are all Seneca Lake. We are all Seneca Lake. And I come from the town maintains, but it's not the county government's buildings, they're the people's buildings. That's right. This is the town hall of the town of Reading. The taxpayers paid for this building. The taxpayers are heating this building, and it's warm inside. The taxpayers have the lights on, and they're paying the sheriff's deputies who are following the orders of Supervisor Schweitzer that says, this is actually not a public building tonight because the members of the public who are here are not allowed. I have to point out that I just think that is an abuse of power. I would also point out that Justice Berry, who is, at least tonight, has let some observers into the 5 o'clock proceedings. We'll see what happens at 7. Perhaps shall be public and every citizen may freely attend the same. It is important that everybody knows that. It is vital that the public ask, what is Justice Berry afraid of? It is time for the public to see what's happening here, and it's time for the public to be allowed in without reservation. Thank you, Sandra, for inviting me today. Thank you. Keep it up. Thank you so much.
Get you a
Wearing of awake.
Paul Passavant, who is not only a defendant and a Seneca Lake defender, but also a professor of constitutional law at Hobart and William Smith Colleges, who very graciously lectured Justice Berry on some fine points of constitutional law and enlightened us all, is here to tell us more about the problems inside and outside the courtroom with lawlessness.
Thank you, Sandra. And it's a pleasure to be here with Martha Robertson and Sandra Steingraber. I just want to note that 3 weeks ago on December 17th at 5 o'clock in the evening, I came down here with defendant Laura Salamandra, but I was stopped at the door to the courthouse and I was prevented from going in. Only the defendant and her legal advisor were allowed to enter into the courtroom there, and that, and so we had court proceedings and it's a fundamental aspect of our legal system that those court proceedings should be open to the public. I have here a particular Supreme Court decision, so we're quoting law today, and in Richmond newspapers versus the state of Virginia, the Supreme Court noticed or argued that a trial courtroom is a public place where the people generally and representatives of the media have a right to be present, and where their presence historically has been thought to enhance the integrity and quality of what takes place. We were excluded from that courtroom 3 weeks ago, and we have reason to be questioning the integrity of those proceedings that took place when the public was excluded there. Now, the DA's office did have party to a case. An interested party is acting as judge. That's completely unfair, and it presents the appearance of a lack of judicial integrity in this court. The people in this town, this county, this region are poorly served by the legal system that we are witnessing here. If this government in Reading and Schuyler County is anything like what we have been seeing in these proceedings, then I've got grave doubts that this government is a secure repository of the public trust with respect to the Crestwood Project to score volatile gases in the salt caverns on the shores of Seneca Lake. What I've seen is that the government here is more interested in protecting corporations than the rights and the welfare of the people who live here, and we can see the very low regard that the government and the town of Reading and Schuyler County consider the public, because they've left the public out in the cold. And that's where we are right now.
Yeah. Well said, well said.
Travesty.
What would you say about-
Press.
What's that?
Comments and questions from the press.
I'm curious why they wouldn't allow us to go in and have our press conference in the lobby.
I asked the deputies. They had no reason. They were told.
Kangaroo court.
They were told by Supervisor Swetzer that was the rule.
It sounds like other people have been allowed into this public building, but it seems like this is just vindictiveness that is targeted against We Are Seneca Lake as a particular political group. That's not a valid governmental objective, and that violates our rights.
And notice that they're not charging We Are Seneca Lake with any crimes. The people who've been charged with crimes, including myself, have had hearings. nevertheless, they're meeting.
That was the rule.
It sounds like other people have been allowed into this public building, but it seems like this is just vindictiveness that is targeted against We Are Seneca Lake as a particular political group. That's not a valid governmental objective, and that violates our rights.
And notice that they're not charging here.
DH, honey, we're out here in the cold. The people of Reading, they won't let us in this public building. Do you have a comment about that?
They won't let you in.
They won't let us in.
Public building.
No, but they let us in the courtroom.
The courthouse is closed. Why?
Courtroom has been open. I mean,
They won't let us in.
they have a sheriff blocking the door.
It's a secret court.
The kangaroo court.
Is there
Kangaroo
anything,
court.
Will you do anything for us?
Public rights.
Will you advocate for us?
You know I have control over this town hall building.
Why wouldn't you?
The courtroom is open.
No, it's not. They won't
Well,
let us in.
The foyer, there's plenty of room outside the courtroom. They wouldn't let us in.
and
And they wouldn't give us a reason.
certainly when the court starts at 7 o'clock, it will be open.
No, it won't. We've been told it's been closed
I was told that it would be open.
Could you tell the deputies that it's supposed to be open?
We've had that conversation already.
We were just
Well,
hoping
that-
for the civility of the town to let us have our press conference
You should talk to
inside.
the townsfolk.
We
Mr.
did.
Why did you participate in a secret court proceeding 3 weeks ago?
You're the district attorney.
Tell her.
Comment though was that we're not prohibited.
I know.
We are.
We tried.
Okay, the fingers are gone. They are gone.
Anybody has twisted
belong to the people of the town of Reading. They are public facilities. It's, my gosh, probably 5 degrees out here, and folks have been freezing to death. And it's rather unusual and frankly unfair, if not unconstitutional, for these folks to be prevented from attending open public court proceedings. So whatever is necessary to ensure that the public courts are open to the public, all of the public, or that facilities that are sufficient to accommodate all of the public, whatever is necessary to ensure that that occurs will be done. And we will pursue this because it is absolutely fundamental. It's part of the bedrock of our Constitution. It's part of the bedrock of all civilized nations of the world to have open public proceedings. And our job as citizens, our job as attorneys, as officers of the court is to ensure that those fundamental principles prevail. And so we intend to proceed in all manner to protect those rights.
Is it within reason for the people here requesting the town of Reading to allow our press conference to be indoors where it's, you know, a little bit warmer than it is out here where it's actually close to zero?
Yeah. Again, my concern has to do with the public nature of the facility, and it has to do, more importantly, with the public nature or the public venue of a court. And yeah, is it unreasonable? Of course it's unreasonable. I think it's vindictive, it's inappropriate, and I would hope that when reasonable people get a chance to evaluate this in a more objective fashion, that some rules can be reaffirmed by higher authorities that will guarantee that the rights of citizens are not trampled on as they are happening, as is happening right now.
Thank you.
All right.
Thank you. Can you say your first last name again?
I'm Ray Schlatter, and I'm an attorney in Ithaca, New York, and I represent Christopher Tate in these proceedings.
Can you spell Schlatter for us?
Sure. S-C-H-L-A-T-H-E-R. Fair enough. Alrighty? Great.
Hey Ray, I'm Colleen Boland.
Oh, hi, Colleen.
How are you? Oh, you're so